depart a little from delinquency today, guys. I think that I told you at one point, I had Marco and George, who obviously the defense attorney, come and speak to you from that end. And some of you may know Chris Cookie's family family's attorney. He also teaches here in the legal writing program. So Chris is going to talk further to you guys today.
Okay, some of you I know from other classes and other places, so I'll get right into it. I have a question. Should it be easy for the government to remove children from families?
No.
Who says no? Okay, why not?
Because it's terrifying for the children. It's, kids love their parents, even the mean ones, even the abusive ones. Kids don't understand, depending on their age, they don't really understand it. They don't understand that they may end up going back. You're taking a kid, you're putting a little kid in an environment that they're not familiar with people they don't know.
Okay, I'll use the word scary to summarize that. Okay?
Yep.
Okay, any other thoughts? Should it be easy? Yes.
No, because they make mistakes.
Okay, mistakes.
There's a fundamental liberty interest too to raise your children.
Fundamental liberty interest of the parents.
Of the parents.
Okay, so we'll call parental rights. Any other thoughts whether it should be easy or hard to remove? Yes.
I'll go with yes, just to be different, for the best interest of the child, because they might be in danger.
Best interest of the child. Any other thoughts about should it be easy to remove?
Based on the fitness of the parents. They could be recurrent drug addicts or...
So you say yes, it should be easy?
Yes.
You're arguing against it? Okay.
Just to be on her side too. So we have a balance.
All right. Call this danger then, how's that? Okay. Other thoughts? Easy, or should it be easy to remove children from their families? And I emphasis should it be easy for the government to remove children from their families? Yes.
I'd say no. I mean, you don't want people to be, you want to protect the kids, but you don't want to be overzealous, and at the same time, you don't want the state to be able to have full control over the kid.
All right. Too much government power?
It's got to be somebody in there that's looking out for them.
Yeah, they're not commodities.
Okay. Call this humanity. We're not talking about a piece of property. All right. Any other thoughts? Should it be easy to remove? Okay. Now, here's a reminder, as law students, the profession that you're about to enter, first thing is you should challenge me when I say easy. What the heck am I talking about? So you don't have to just sit and accept the words I use. Now, for the rest of your careers, when someone asks you a question, nothing wrong with saying, hold on, what the heck does that mean? Easy to remove. Well, that's okay. That's just as an aside. Now let me ask you a question. Those of you who said it should not be easy, what if there is a child who is about 4 or 5 minutes away from having his head held in the toilet while someone else hits him with a 2x4? Should it be easy to remove that child?
Yes. Yeah.
Everybody agrees with that. What if there is a child who doesn't really live on a balanced diet, he's only bathed maybe once a week, and he's never been to the doctors? Should it be easy to take him or her from the parents?
Do you want to clarify?
Sounds like my father-in-law.
Right. Should it? So the question is, what standard does the government have to show? Which is another way of saying, should it be easy or not? In other words, burden of proof. Do you think, now you all know that DCF is part of the executive branch, ultimately reporting to the governor, so it's on that particular branch of government. So what, if any, role should the courts play when there's a kid I'll use this example. You know, this is the class you chose to take, so some of the facts can be gory. Okay, you've got a child, his head's in the toilet, while another adult is hitting him with a 2x4. Should the executive branch be allowed to make that decision without going to the judicial branch?
Yes.
Yes, it should be. You say yes, because why? It's an emergency. Does anybody disagree with that? Do the courts play any role in the fact pattern I just gave you? Okay, and how?
Once you remove it, you can go to the court immediately and ask for an order to go in and get the child.
Okay, what if I'm a social worker and I'm here for a routine visit, I hear this commotion in the bathroom, I look in, and I see the fact pattern I just described. Where is the court at that moment? In terms of what role should the court play?
Once you remove the child, then you're going to go to the court.
Why do I have to go to court at all? I mean, it's so clear as to what just happened, right?
There has to be a hearing.
There's a 72-hour hearing.
Would the police get involved in that type of
So
thing?
you've taken Paula Collis's class. 72-hour, or you're a plan. That's good. That's right. That's what it's called. The parent, I'll deal with your question in a second. The parents have a right, as you know, as you've already been taught, it's a statutory right, to a hearing within 72 hours. Somebody said mistakes. Okay? You know, what if I am a brand new social worker who's been on the job for 10 or 20 minutes, I've lived a pretty sheltered life, and I take a quick look at the bathroom, but I'm kind of scared. What if I'm wrong?
You could be wrong, because my father did that to me once. When I was a kid, he had me put down and pretend to flush the toilet just to play, and he was making me laugh, but it could be scary, someone just walking in.
It could be. It's kind of,
I remember that.
it's kind of scary now.
Now you're fired.
Can you wait for 5 minutes after I leave before you get out of your chair just to sit? Okay, so the court does play a role, but if the child has been, if there's an emergency, at least one of you agrees I don't have to go to court. What if I just walk in and the house is filthy? I mean really filthy. Like I get out of my car and it's wintertime, the windows are closed, but I can smell it from the street. I promise you I'm not making up these facts. Oh, by the way, I have to do one disclaimer. Anything I say does not represent the views of the Department of Children and Families, and I'm here in my own time. So this is not TCF taking a position on anything. Right? I don't know if anybody's taping that, but please make sure. That's
You're
included.
online.
You're online.
Well, this online students.
Oh, good.
Listen to the class.
I'm sorry, I missed the beginning. Are you a DCF attorney? Is that right?
That's what you get for being late, Leslie.
Okay, I know. Sorry. DCF attorney.
All right.
So in that case, it will depend on different circumstances. If you're living in a home where the kids are little, if the homes are, there's somebody there, the mom and the kids are teenagers, or that will have to play,
Okay, let's assume that I walk in and I find the place to be filthy, the kids are dirty, and there's no food in the house. Should the court play a role in that right away? So you think I should go to court first?
No.
Oh, no.
You don't think I should?
No, I don't. House is dirty, you said the kids are
Who called in
right?
your scenario, Chris, when you walk into the filthy house?
Good
Who's the
question. Home
reporter?
visit, just doing a.
Oh, you're already involved with the
Yeah,
family?
the parents have invited me in to
Okay.
provide some service. Okay. Any thoughts on that? What I should do in that case?
I think you need to ask a few questions.
Okay. Okay, I've asked a few questions. I don't like your answers.
The children have needs, what?
Say it's what I personally consider to be an unsafe period of time. I think kids should have balanced meals every day, 3 times a day, and they haven't.
Well, it's not your standard that I'm concerned about necessarily.
You're meeting the social.
But I'm the one in the room. I'm the one in the room.
But whether we're deciding it's an emergency or not, we have to base it on the standard of have the kids, did they have lunch this afternoon in school when you said there's no food in the house? I'm deciding whether or not
assume that they have eaten. How do we know? How do we decide standing in that home? I know this isn't a class on social work, but we'll talk about how this matters in a minute. I'm in the home. How do I decide whether I need to be in court or whether I need to remove? What do you think?
You look in the refrigerator, the couple cabinets, and the sink.
Well, what am I looking? How do I know them? How do I know? What if I didn't think of that?
Talk to the kids, yeah.
Talk to the kids.
Talk to the parent.
Now, the fact that everybody has a different thought as to what I should do illustrates the fact that if someone said, these are human beings, this isn't a piece of property where I can take out my surveying tools and say, well, I can tell you the exact dimensions, I can tell you exactly where the trespass is, and I can do all the measurements and make the correct decision. There is no correct answer. And what the law sort of views is you've got this emergency. Everybody agrees that observing violence is probably an emergency where I don't think anybody thinks the court needs to be involved in that. Second, versus the more subjective, this is bad parenting, I don't like the looks of things, I, the government agent, am now going to remove their kids. Most people think, I hope most people think that would be a horrible society, where the government has the authority to enter your home and say, this isn't my style of parenting, I'll be taking your children now. No one wants that. And I think that on the other end of the spectrum, everybody agrees. If the government knows that a child is suffering horrific abuse, there should be a way to take immediate action. And here we have the challenge of a free society, right? Because there's no question, if we give the government unlimited authority, children will be safer. There's no danger of any child being hit if social workers are in every single home. Every home is assigned by the government a monitor. Every child will be reasonably well fed, reasonably clean, and probably not in any danger of violence. It's an absurd scenario, and a society we would all be terrified of. The other scenario is, well, people are free to do what they want. There are parental rights, which means you don't intervene between what a parent and a child are doing. So that's why, obviously, you have to have judicial oversight. So here's the question. The next question then is, what exactly should the courts be looking at? Remember that little exercise of about 3 minutes ago? Everybody has different ideas about what ought to happen. How the heck does a judge decide? Yes?
The best interest of the child.
Is it the best interest of the child? Is it the best interest of the child that we look at?
I think they should.
Let me ask you a question. If I am well, let's take the people out. If a parent is a mediocre parent, and the kids very rarely go to school, just enough so that they're not violating the truancy statute, if they eat really unnutritious food and every child in the home is obese, and the parents don't value college education, they're not going to save any money for college, they don't care about exercise, and the kids are just really suffering because of the opportunities they're missing. Is it in their best interest to be in that home?
No, depends on what the alternative is.
Because the alternative, if DCF gets in there, as we see in a lot of our cases, the children end up in foster homes, 17 of them by the time they get to 17, and then they're messes, and they're into drugs and pregnant and God knows what else, because they have a unstable home life, so they may be better off in that other environment you described.
So my question is, I don't know if you've covered this yet, but at the 72-hour hearing,
They have.
you have. It's a very, very low burden of proof. Because it's not what's in the best interest of the child. It's whether the child is in, do you remember? I wouldn't expect you to remember, but it's
Reasonable cause, or reasonable.
imminent risk of, you remember that? Imminent risk of serious abuse or neglect. Not what's best for the child. At that emergency level, it's not what is best for the child. It is, if this child goes home tonight, is that child at that level of risk of abuse or neglect?
By what standard of proof? If it's a 72.
Okay, preponderance of the evidence, is that a high standard or a low standard? Pretty low. It's the lowest standard, actually. So what does that mean? Is getting back to my original question. Is it easy then? If you'll now permit me to use the word easy. And we're now at the hearing. We've already said, well, there was this horrific violence. There was obviously no standard of proof at that moment because there was no court involved. We have a member of the executive branch saying, oh, it's all based on what I'm thinking right now, what I'm seeing. Child's at imminent risk. Boom, remove it. Now the courts are involved, and we've got this preponderance of the evidence standard. Is it getting easier or harder for the government at this point? Not by much. Not by much. Still, now, what do the parents have to prove at this hearing? The child has been taken away from them. What is their burden at this point?
Prove parental fitness.
Anybody agree with that?
Nothing.
Who said no? You? Parents have no burden. They're free to show up and say, here I am, like my child back. Which is, I think you'd agree, I hope, that's the way society should be run. Why should anybody have to come before the government and say, let me now prove to you why it's okay for my own child to be with me? I mean, think about this in the larger sense. Families have existed a lot longer than governments have, right? Family units have been producing children long before there was ever a government on the planet. So it's, one would think, a good thing that a parent is free to come forward and say, here I am, I want my child to prove to the court that by a preponderance of the evidence I shouldn't take my child tonight. And as you probably have already learned, throughout all of these proceedings, all the various subsequent hearings and trials, parents never have a burden. It's always on the government, which I think you may agree it should be that. Because you think about the alternative, what kind of society do you want, where the state, small s state, has the authority to bring you forward and prove to the court you're okay as a parent? So, first of all, any questions so far? Are these things that you've already covered ad nauseum?
This is great.
All
It's a
right.
good review for them.
Okay, good.
You've forgotten some of it.
Yep. Now this spectrum that we put together in the first few minutes of class is an omnipresent thing. If you end up going into this line of work, there's a constant tension that is never resolved. I would suggest should never be resolved as to what should happen. Because sometimes we hope, we work hard to make happen, the conditions that cause the parents at this end of the spectrum to lose their children temporarily improve. Sometimes, frequently, it's substance abuse or other issues. And as those conditions improve, obviously the pendulum moves the other way and the kids go home sooner. I mean, that's our mission. We don't exist to remove children. We try to get children back into families as soon as it's safe. But if you become a practitioner in this area, you're constantly dealing with the question of where am I on this spectrum? And there is no guidebook you can take out and review. This isn't banking. There is no grid. And if you end up in a position where you're advising social workers or families, and they say, well, what has to happen for the kids to go home is a matter of law. How do you think you could advise someone? Any thoughts? The kids have been removed, the department admits low burden at the initial hearing. Now the parents, your clients, want their children back. Well, if you're representing the government, the social worker is thinking, when do they get their kids back? What do you think you might advise them? Any thoughts? Yes.
Well, we'll probably want to start by following the DCF service plans to show that you're complying with every effort to be reunited with your child.
Okay, as an evidentiary standard, you want to say, I'm
Yeah.
doing what the department has asked me to do.
Right, so that when they're trying to make their case, they can't say you're not complying.
What if you don't agree with the service plan?
Then you would probably still want to talk to DCF and explain why you don't agree with it and ask for something better. Something for it.
So at that point, you're advocating for your client. Let me give you an example. You represent a client, and you all know what a service plan is at this point, I assume. The service plan says substance abuse treatment. Your client says, I don't take drugs. I don't use drugs. I never have. Now, you've correctly pointed out that compliance with the service plan is a way to get your kids back. But your client is saying, I don't want to go to substance abuse. I don't use drugs. Here's a hard question. You could say to your client, just do it. If you comply with the service plan, you're more likely to get your kids back. Or, what else might you say to your client?
Prove it.
You say to your client, the parent,
We have to prove that you don't use it. Right. We have to offer evidence showing that you don't.
but what about my earlier statement that the parents never have any burden of proof?
In this instance, they do. If they have a position that they want the court to believe, and in order for the court to believe it, the court, as you said, the court doesn't go, the judge does not go into their home or be out of the courtroom. He needs to have some kind of evidence that shows that the parent is telling the truth.
Okay, back, yes.
Well, my problem with telling the client to accept that he has a drug problem, if he doesn't, what if his employer has a drug policy? Now he loses his job, and does he get his kids back if he doesn't have a job? So I think that creates even more problems. You really have to look at the whole picture, not just looking at getting the kid back.
What if he says, if my employer finds out I'm in a drug treatment program, I lose my job?
That's what I'm talking about. I wouldn't know what to do with that one. Because now you have two problems. You lose your job, you're probably not going to get your kid back. So,
This is a hard job suddenly, isn't it?
Wouldn't you want to put the burden on the state to prove why they want the drug treatment plan in place? Do they have any evidence that he's on any drugs? What is their basis of putting it on? Is the challenge back on the state?
Okay, I'm really glad you answered that. We have two different points here at opposite ends of a different spectrum. On one hand, you've got the correct position that I never have any burden of proof if I'm on the parent's side. The government has to prove everything, just like in a criminal case, the government has to prove all the elements. But then we have what I would call a common sense approach that says, well, I know we don't have a burden of proof, but because I'm afraid of that scenario right here, let's take a burden of proof on our shoulders and call the government to task and say, fine, my client will pee in a cup every day. You can check the urine as often as you want. And we will prove to you that the client is not using drugs and that the service plan should be amended. And if you don't amend the service plan, that's fine with me, because when we end up back in court, we'll be using this as evidence against the department. And that's advocacy, in my opinion. I mean, it's easy to sit back and say, I don't have any burden of proof. It's a stupid thing in the service plan. Let the government prove you're abusing substances, and they'll never prove it because I don't want you ever to pee in a cup. And as a matter of law, that's not an incorrect position. What it's not is listening to the client who's saying, I really don't use drugs, and I really want to get my kids back. Okay, well, then we're going to prove something, even though we don't have a burden of proof. Now, as practical attorneys, what is the one risk in doing this? What is the one risk in this plan?
He's lying.
Yes. I don't want to shock you, but you're entering a profession, and sometimes your clients lie. Or in fairness to them, sometimes they just really don't understand what they're saying to you. Or they're being overly optimistic. And this is something that I never learned in law school, but the importance, I think we almost have a class on client interviews. Because the fact that your client says I don't use drugs, they may come from a world where not using drugs today is the same as not using drugs. Okay, if you're in a real party atmosphere and someone says, hey, are you drinking these days? No, I've had nothing to drink since last night. Okay, and, I mean, I laugh about this too, but there are, just because all of us are responsible adults, it doesn't mean that there aren't people. So if you fail to ask the second or third or fourth question, you advocate, fine, we'll pee in a cup every day to check the urine, and, well, okay, gee, there are opiates in your urine. Did you use drugs? Yeah, not today. I use drugs. When I tell you I don't use drugs, I mean, I'm not like my friend Joe over here, who's high all the time. So that's what happens. That's the risk you take. And how do you get a client to tell you the truth? Well, that's why this is an art, not a science. And over time, you'll develop an instinct, whatever profession or area of our profession you go into. And it's not just these poor folks who have their kids involved with DCF. You can be representing very successful people in business, and they'll tell you, oh, I absolutely didn't run that red light. And then there's a camera that shows they did. So, always want to think. We'll see on television sometimes, people will criticize attorneys for not letting their clients say a word. And the reason is because unless you really and truly have a rapport enough with your client to be able to gauge whether they're being truthful, it's just too risky. Because if we took what I think is your good common sense approach, and the person turns out to be positive for drugs, guess what just happened? The case is now spiraling out of control. And DCF is now heightened. From my perspective, that I have to argue, we're properly alerted to the fact that there's drug abuse. So now we're trying to get help for this person, but yes, that will delay the reunification of their children, which is clearly not what you wanted for your client, because you're in compliance with everything else. Do you see why there are absolutely no single answers to a single question in our profession? Every now and then we all run across students, what is the answer? And the answer is analysis, not an objective reality, but what type of analysis do I get? And at the end of the day, I think someone over here, maybe it was you who said it, you really don't know the best course. All you can do is advise your client and say, look, here's the situation. We don't have any burden to prove you're drug-free. But if we do, we might get the service plan amended and you get your kids back. But I'll tell you, if you fail these tests, say goodbye. That's why it's really not your decision as the attorney anyway. But it is your duty to explain all the implications. You know, it's very difficult to say to a client, you know, you've never been honest with me, you're probably lying now. So you're diplomatic and you say, look, I believe you, but the fact is, if it comes back positive, you're a long road ahead. Now, what is something you know, or can you remember something very unique about these proceedings, unlike other proceedings in Massachusetts? They're closed to the public. The public has no access. Some of you have done internships, and hopefully you're told that you can't discuss anything that you hear when you go to these proceedings. Now, why do you think these are closed proceedings? What's the good thing about proceedings like this being closed? If anything, maybe you don't think they should be closed. Yes?
It helps protect the child so that in the future they're not maybe hurt by any outcomes or situations or ridicule and things like that.
Protects the child, right,
Yeah.
especially ridicule or things like that. Because what has the child generally done wrong in these proceedings?
Nothing.
Nothing. These are not delinquents. The child has done nothing. Well, what's wrong with having closed proceedings?
There isn't the same accountability to the public.
Lack of public accountability? I would agree with that. What's another thing that you would argue against having closed proceedings?
On accountability, it's also personal accountability. A parent may not be as embarrassed or humiliated by his actions because he feels it's only within that space, no one will know.
It gives a sort of a harbor for wrongdoers. It's confidential, okay? You?
I also think it might be a problem for other people. For example, with sex offenders, you have to register and you learn about them so that if your child, you know, you can make sure your child doesn't go near them. So in these cases, if they're closed and you have a child that you allow to go to that house and you're finding out, you will never find out that they're either neglecting your child or abusing children. So you wouldn't stop sending your children there.
That's a good point. I'll tell you one thing that the statute has changed. DNR orders, do not resuscitate orders, they are now open to the public. That's a change in the statute.
Chris, I have a question. You know, we were talking about the YO cases and how those are open to the public. But what I was saying to the class the other day was, when you have all the other cases that are obviously closed to the public, how does the public know? No, for example, you can walk into this YO case, this is going to be heard today on the list amongst with delinquencies and chins and whatnot. You know what I'm saying?
How does the public know that the YO
Yeah.
case is even happening?
Exactly.
I agree with you. I don't know why.
Okay.
It's a good question. I think the only thing I can think of as an answer is that because it's a delinquency and there's a victim, unlike a parent protection where there are no victims, the victim's probably informed of it in that person.
For example, what you just said in the DNR cases, even though conceivably they're open, does anyone really go that's not involved? Right?
Yeah, it's a good point. It's a very good point. You know, sadly, most families don't even have any interest in going. They extend it to the ones because it's rare when that even happens. Okay, now, talked about this constant tension between, you know, we want to keep kids safe versus the rights of parents. You think of other people who have rights or interests in these proceedings? Did you notice the difference in those words, rights and interests? Who do you think has a right at stake when children are removed?
You want the child's parent?
The child has a right, parents have a right. Think of any of the rights that are implicated? Yes?
Siblings or grandparents?
Siblings or grandparents? That is an excellent question. Do siblings and grandparents have rights when the government reaches into a family and takes children out?
Grandparents don't have an interest, they don't have a right.
Right.
Okay. Grandparents have an interest, they don't have a right? Do you have a position on that, or are you just raising it?
No, I think there's interest for the grandparents. I think there's an interest for the kid, for the siblings. I think there's definitely a right that their family doesn't get broken up, but I don't have a lot of that.
What do people think about it? Yes.
I was gonna say, unless they're a party to what's been going on, they're part of the investigation.
Okay. All right. That's a good procedural point. You all understand the difference. I might have a right and interest. For example, let's put it in real estate terms. I own some property as a tenant in common, and my partner has been sued, and she now has a lien, or is about to get a lien. I'm not even part of these proceedings. I'm not a party. But do I have a right that's floating around out there? Sure I do. Sure I do. I have a property right, but I'm not a party. So, party status is when someone sort of perfects their position. So, I'm spending time on this because it's a good and subtle point. It's a separate issue. And in fact, someone with rights and someone with interests, they want to become a party. Do by a motion to intervene, right? Or a motion to amend the complaint. So the question, though, is, do siblings, do grandparents have a right at stake which would enable them to be a party? How do we answer this question?
What is it right?
This is a trick question. How do we answer any question in the law?
Analysis.
If you two don't know the answer, I wasted a whole summer with you. What?
It depends.
It depends. That's right. How do you answer the question? That's actually true.
Analysis.
By doing what? Case law. Case law. So none of us really know the answer. But my question to you is, I mean, I'll tell you, they don't have rights. Siblings don't have rights under the law that I'm aware of. Grandparents, it's an evolving question in Massachusetts. But my question to you is, should there be sibling rights? Should there be grandparent rights?
Yes.
Or aunts and uncles? What about next door neighbors? What if it's a mother with a boyfriend who's acting like a father? Depends.
Could have to be guidelines.
So if you were writing a statute or if you were advising someone on how it ought to be, how is this possible? Where do we say people with rights? Now obviously, that whole list I just went through, all of those people have an interest. They're involved in the children or the family's lives. They want to help. They want to be available as a placement maybe, which is a whole other subject. So they have interests in the case. They might even argue, my interest is so great, I get to move to intervene and become a party. And if I'm a party, all of a sudden now I have procedural rights at a minimum. But where would you draw this line? I'm curious to know what people think.
Between sibling and grandparent.
Where does the line of rights? I think we all agree that the child being removed has a right at issue. And I think we all agree that the people who biologically produced that child or adopted that child have a right.
And that's why they all have a right to counsel by our mass statute.
Right, that's correct. But who else, if anyone, maybe you think that's enough. Does anybody think nobody else should have a right?
Well, the state has one. I think
The state.
probably.
We'll deal with that unpleasant subject. Who else, if anyone, should have rights? Yes?
The de facto parent,
Okay, a de facto parent. What is a de facto parent?
Someone who stands in the position of, who takes care of the child with the parent's permission, lives in the household, and the child considers to be a parent.
It's provided for the child.
Not biological.
Not
Not a biological.
Right. Yep.
And there was one phrase in that sentence, someone the child considers to be a parent. Does that person have a right, though?
I would argue they do.
Okay, it's an argument. And how do you think you'd make that argument successful? What piece might you want to be able to, if you want to successfully argue this de facto parent should have a right?
That the child considers them the parent.
Right. And actually, this is not a bar prep class, but this is advice I was given when I was studying to the bar, and I think it's true. If you have any question involving kids, or people fighting about kids, and you don't know what the answer is, what do you think the answer probably is? All right, I almost promise you that's going to give you a point in the parts. Because it's always, I can't think of any fact pattern where the best interest of the child isn't the correct answer. No matter how complicated it is, if there's a kid in the fact pattern, just follow it through and at the end, best interest. And that's, you know, again, we talk about what type of society you want to live in. Shouldn't that be paramount? It's in the best interest of the child. Unlike an emergency removal, we're not talking about what's best for the child. We're just saying this child's subject to imminent, right? And that's analogous to, again, I keep getting back to property law because it's one of the few objective areas of the law. You know, one of the great defenses of trespass is an emergency. Remember that class if you took property where someone was allowed to tie their boat to a private dock because there was a storm coming?
Yes.
All right. So, we've said maybe a de facto parent. Should anybody else have a right when a child is removed?
Grandparent.
Grandparents. This is an interesting question. And as Paula said, a right means you get to show up and say, if you happen to be indigent, the government now needs to give me an attorney, which all of you and me are going to pay for. And so you're saying maybe the grandparents should do it.
Because sometimes the grandparents are more parent than the parents.
What if the grandparents disagree with the parents? Should there, if they're parties, they have an equal say in the argument, in the proceeding. What do you say about that? Yes.
I think a guardian should.
The guardian. Okay, because a guardian has already been adjudicated to have an interest with the child.
Right.
That's a good point. That's somewhat akin to an adoptive parent. The court has bestowed a right. But let's look at the grandparent question, okay? If the grandparents have a right at issue when the child is removed, what about cases where the grandparents, the mother says, I hate my parents, we're estranged, I don't want them here. How would the pro-grandparent view handle that? What would you say? If you think the grandparents have a right, what do you say if the biological parent says, I don't want my parents around?
I don't think grandparents.
You don't think the grandparents have a right? You don't think, anybody?
They don't have one, but I think you have to always look at the totality of what his circumstance is. And
So how would you draft things? How would you give grandparents rights, if at all?
Well, I'm a grandparent, so I'm calling for the rights. And I have biological, physical custody of my granddaughter, so I know I have rights, but,
But in that case, you have custody because the courts have given you
Right.
rights. Right,
Right.
not because you're a grandparent.
right, no. So, what's the question?
The grandparents, no, I'm not laughing at you, I'm just,
No.
take a good job by me explaining it.
Right, so, no, so.
Should the grandparents have rights, and if you say they should, what do you do when, yes?
My question is, which grandparents get rights? The mother or the father's parents?
What do you think?
I don't believe grandparents should have rights. That would be my question at that point. Who, if you have two sets of grandparents come in, both wanting to pull in different directions, which one should have more rights over the other?
Good question, yeah.
I was gonna say, on one hand, parents have a fundamental right of how to raise their children, but it's not absolute. But on the other hand, I think it's important for the courts to look at the facts surrounding what the parents want for their kids and what the grandparents want and weigh it in, and then, in terms of the best interest of the child. I think it's
On
more
parties,
of a
on whether you assign rights?
I think it's more of a case-by-case basis if you're looking on the other end, whether the grandparents should have rights or not. Maybe find out their point of view if the parents disagree with what the grandparents want. But
And here's a follow-up question then. So you're saying it's situational, look at the facts.
well, on one end, but
How do the grandparents even get to a point where they're being considered? If these are closed proceedings, how, can anyone think how the grandparents can even know what's happening? If
Only when the parents are considered unfit and determined to be unfit, then the grandparents would then acquire some rights.
Well, what about this early stage where the government is just taking the children away? And those of you who think grandparents have rights, what would you say?
Well, I don't think grandparents should have rights, but I was going to say the only time I think that they would come into play is if the grandparent was acting as a de facto parent. Because if you don't even live with your mom and dad and you're just spending all your time with your grandparents or your mom's never home or something like that, then you consider your grandma. You might know it's your grandmother, but you consider them the authority.
So that's a de facto argument.
Yeah.
It's just coincidentally happened to be a grandparent.
Correct.
Yeah.
I think that it might come as parents don't show up. When you have that 17-year-old hearing and there's no parents.
Okay. And who should be finding these grandparents?
We should be what?
Finding the
Finding.
grandparents.
Finding them?
Finding them.
Finding. The social worker.
Social worker.
Social.
DCF.
We would argue the state should find them.
Child attorney should.
Child's attorney should find them.
whoever's advocating for the child.
Okay. What is the argument for the child's attorney finding the grandparents?
It's the best interest of the child, so,
Exactly.
yeah, you're advocating for the client to put him in the best positions.
What if you're a client who's 12, let's say your client's 16 and says, I hate my grandparents.
I don't look for
Then don't look for them? Okay, so you're saying, your answer is actually focused on what your client wants. You're not so much saying grandparents have rights. Because remember, if you have rights, it's not an open question as to whether you have a chance to be heard. Rights means I have a right to be heard. You have a, I hate to use the word in the definition, you're entitled to demand to be heard. You have a right to be heard. Your proposal is, if it serves my client's interest, you're darn right I'm going to find these grandparents. But you're not saying that they have a right. Who says, who can argue, I don't care if you agree with it, who can argue that grandparents have a right? Yes.
I would say, I would argue the grandparents have a right because they have a biological connection to the child. It's only once removed, and they also know the parents. So they're gonna have more of an awareness of, the child's best interest. I know it could conflict with the parent, but of course it always has to do with the case-by-case basis, because, for instance, what if these parents think it's okay to prostitute their kids out to feed so they can all drive a Cadillac? And the grandparents don't agree with that.
Yep.
It's like, what's the best for the child?
Well, here's a question now. Thinking like members of the legal community, we have to think by analogy sometimes. Can you think of anything that exists in the law? Forget about family law for a minute. Can you think of any example in which other family members have rights by statute to property? Not search and seizure. Can you think of an example where family members, by operation of law, have rights in property?
Well, I was just gonna say that if the
No,
parent.
I'm gonna cut you off because I'm asking about,
Yeah,
you think,
question. Yes.
but argue, yes.
When you die, intestate.
Intestacy statute, that's right.
Right.
The intestacy statute says, obviously paraphrasing, if somebody dies without a will, suddenly all these people who have nothing in common perhaps but genetics, have a right to claim parts of the estate. It's not about whether grandmother was, actually, whether the parents were good to this adult, or whether the siblings were nice people, or whether the children were any good. They have a right. They have to show up with a birth certificate and say, this is my brother or sister, this is my mother or father, this is my child. And the statute says, I have a right to get a piece of this. So there is, maybe you could argue by analogy, that we already have an example in Massachusetts that says certain family members are automatically included. Now, what's wrong with my argument? What's wrong with that argument?
Too large.
Well, it's pretty tightly defined.
Well, it's a difference between money and people. I mean, with a testacy, you're just giving away things. You're not dealing with human beings. With dealing who's going to take care of children or have an interest in their child, you're dealing with real people.
Yes.
And I would say the question of what you want doesn't matter anymore because you're dead and you chose not to have a will, whereas in this case the child is alive still and it's going to affect him or her.
Two good points. I mean, we're getting close to running out of time, I think, aren't we?
No.
What do we have to?
2:15,
Okay.
2:20.
This is why at the very beginning I noted that the hard part about this area of the law is it's not a science. And this is the point right here, which is money doesn't care, right? Money just follows money. Money follows interest. There's no best interest in money, setting aside fiduciary stuff.
I have 2 points. One is the department's mandate is to strengthen and encourage family life, not just parents. And the other point is, here in the U.S., we are a melting pot. And most of us, I mean, I come from a tradition that, and Billy will joke about it, that when the department calls it, when you have a care and protection case and it's a Greek family, she mentioned everybody, including the priest, walks into the courtroom and the judge is like, but they're all included in the choices that we make and the family life. And I mean, I lived with my grandparents, and now my children also live with their grandparents, my parents, and so forth. So, and I know a lot of people are like that in this society. So
It's true. And I mean, again, I'm not here as a representative of the department, but it's just a statutory fact that the department has an obligation to try to place children with family members. And that's the good part of the story, is that the executive branch tries very hard. If a child is removed under these terrible conditions, we want to find either a de facto person that knows and loves the child with a proper biological relative. And I think we would all want a system that works and it should work. And plus, it's common sense.
The department's mission doesn't give the other family members rights necessarily.
That's correct. It doesn't give them rights, but what could they argue they're entitled to? If you're one of these family members, what do you think you're entitled to demand from the department?
I would hope to be informed, but I'm not sure that that's right.
Okay, let's,
First consideration.
well, what are you entitled to demand? If I'm right when I say that the department's regulations require placement with family, and you are one of those family members, what do you have a right to demand of the department?
Right to be heard
Heard by whom?
by the court or by DCF.
Well, those are two different things, because
Right.
DCF is the executive branch.
Right.
What do you have a right to demand that DCF do?
That somebody listen to your reasoning or rationale as to why you should have rights to the children.
This is something that applies to the practice of law even outside of this area. You deal with any form of administrative law, any form of government, rather any executive branch form. What are you always entitled to demand that the executive branch do? What does everyone have a right to demand that the executive branch do? Yes?
Consider you in equally at the beginning as all
Equally? I want more than equal treatment when I go to my government. What does every person have a right to demand that whatever executive branch you're dealing with, what do you have a right to demand that the executive branch do? And I'll tell you the legal significance of this once you answer. The answer is follow its regulations.
we talked about this, the Isaac and Jeremy cases, the visitation issues, the custody issues. DCFS custody should be following its own rules and regulations, 110 CMR.
Franklin Roosevelt, and I don't know if I get this quote exactly right, but he said, compliance with the law is demanded as a right, not asked as a favor. You don't go to the government and say, I'm the grandparent, would you please consider me? Go to the government and say, you must follow your regulations. Now, suddenly, do we see a way to intervene in the case? If I am the grandfather, and the department refuses to consider me as a placement, they just don't like ball gags. The department won't consider us. And I know these proceedings are going on because I want the child placed with me. This is my grandson. I love him. I have to go home. And DCF won't even talk to me. What can I now do procedurally? What I might not have been able to do otherwise, what am I suddenly able to do?
Look at their regulations and demand that they follow.
And they say, sorry, we don't like ball guys. Done.
Is that in the regulation?
No, it's not. They just say, sorry, we don't happen to like you. They don't happen to like you. I'm kind of a pushy guy. I come in and I say, hey, I'm the grandfather, give me the kid. And they look at me and say, well, we don't like you. We don't like your attitude. We don't like the car you drove in. And the fact you're wearing a necktie means you're a patriarchal person. We don't want you. Right? What do I do? And I know these proceedings are going on down the street.
File a motion.
Right, now perhaps I can file a motion to intervene. Maybe the court won't allow me to do that, so how else might I get my case heard? You're right, I'm going to move to intervene because I'm saying, hey, there's a placement hearing going on, and I want to intervene. And for whatever reason, the court says, well, we're still not sure about grandparents' rights, we're not going to allow your motion even to see the light of day. How else might the grandparent get heard? It's a very specific term, it's called an abuse of discretion
You
motion.
guys have heard that.
Abuse of discretion. Somebody, but who? I'm the grandparent. There's these proceedings going on. I can't get into the courthouse because it's a closed proceeding. How is the court going to hear my problem? Yeah.
File a claim for abuse of discretion against DCF.
Am I a party at this point?
Now you're a party,
But I went to the clerk's office. They said, we don't think grandparents are parties. We're not going to,
but it's its own suit. It would be its own, you're starting your own complaint.
One thing is, could I file my own complaint? That's an idea. But the proceeding's going on tomorrow. What am I going to do? Can you think, if you represent me, the grandparent, and I tell you I want to be considered in that placement hearing tomorrow,
It's an emergency motion.
Motion to intervene?
okay, motion to intervene, it's not going to happen in time, I have to give notice.
Indispensable party.
I'm not a, what's that?
Indispensable party.
Indispensable party, maybe if I can get in, but there's already a proceeding with parties already in there. And you're the attorney, what might you do? Who might you work with?
You go for an injunction.
Child's attorney?
You might contact them, and this is where we talk about being, as an advocate, looking at a way to solve the problem. You say, well, first of all, I'm representing you, the grandfather. I'm going to call the kid's attorney because, frankly, if the child doesn't want you as a placement, let's find out now, right? Don't ever lose sight of common sense when you practice. It's not just about applying the law. It's thinking, what can I get from my client to serve his or her interest? Okay, grandfather, I'll call the child's attorney. Grandfather is here. Would you like him as a placement? Yeah, we'd love to have the grandfather. But the department won't even review him. So what might I say to that child's attorney? Why don't you file a motion for abuse of discretion? Suddenly the whole question about whether we have party status, the grandparent, is irrelevant. Because we have, by applying a little common sense advocacy, we've contacted the child's attorney, and the child is now saying, hey, I want my grandfather considered. DCF wouldn't even talk to him. The government abused its discretion because it failed to do what? Follow its own regulations. And incidentally, that's all that the court can order the executive branch to do, is follow your regulations. You have to do a home study of Chris Cook, you consider him, and you can only deny him after you've followed your regulations. But what you've done for your client is, instead of all of these creative and probably successful ideas you've had, which will A, cost money, and B, take time, and C, might not work. In a very quick fashion, you've addressed your client's problem, And you've done it in a way that actually everybody is now benefiting if you're successful. And who's a stronger person in the eyes and ears of the judge? The child articulating to counsel what he or she wants, or this external satellite person? Again, common sense. The judge is supposed to be looking at the child's best interest at all times. And if the child is taking this position, as a matter of law, it shouldn't matter, but as advocates, we're thinking, what's the most effective way to get our message across? That might be the way to do it. That's the great thing about our profession, is we're officers of the same court. We reach out to each other and we communicate. We encounter attorneys from time to time. It's a tiny minority who are just unpleasant, uncooperative people. I think that's good advocacy, but in fact, by closing off other members of the profession, you don't get a lot of work done. This is where you just call someone and say, hey, I think we have a common interest here. Or not, I'd sure like to find out. Because if the client doesn't want my guy, let's save us all some time and money. And you're beginning to see that the common thread of all these questions is, gee, who knows what the answer is? We don't know. And sometimes when you're faced with a really hard question, does a grandparent have a right or an interest? Sometimes you get to avoid the hard question by saying, well, what does he really want? Maybe I can get that without addressing the really hard question. It might not be always that easy to prove, and instead get there a different way. Is anybody confused about anything yet? Or lost? All right, just want to cover a couple of more points. Now, should it be easy? No, I've already got away with using easy, so I won't do that. When the government seeks to terminate parental rights, should the standard of proof be high or low? What do you think about that? You understand termination of parental rights means you've already had this initial emergency. The child's been in the custody of DCF. The government has said, we don't want this child ever to go home to bio parents. We want to make him or her free for adoption. Any thoughts at that point? You said high, I can't talk.
Has to be very high, the highest.
Well, I'll quote Judge Blitzman. Oh, that's it.
That's a good
I'll
one.
quote. I'll quote Judge Blitzman, who says that termination of parental rights is the capital punishment of civil litigation. It's a very, very serious matter. When people tend to dismiss juvenile court sometimes as not dealing with heavy issues, I'd suggest to you that, from what I said, that parents have been around a lot longer than governments. And for the government to reach into a parental situation and say, you've lost your rights as a parent, you can argue that that is unnatural in a sense, in the nature. You can't take away a biological status, can you? Well, by statute, you can. It is a serious matter. But what are your thoughts? Why should the government be able to do it, first of all? Does anybody disagree that parental rights should even be terminated?
In extreme cases.
What's an extreme case?
Total physical abuse.
What about a little abuse?
There's got to be a line drawn.
Ah, the line. Right. For the last 45 minutes, I think we've identified that drawing a line. I don't know how to do it. The more I do this, the more I don't see it. So, how do you know? Again, it's really easy on the extreme cases. Someone who's been raping their children over the years, or prostituting them, or giving them heroin, or all the other things that people unfortunately will do. That's not really a hard call for most of us. What about the person who has a low IQ, but they're not disabled, and they sometimes drink too much, and they sleep too much, and the kids never get dressed properly? Should those children never go home? No. Maybe that's the other end of the spectrum. What about everybody in the middle? How do we decide that parental rights should be terminated?
It has to be a test.
Hmm?
It has to be like a test where all these factors involved, and mostly what's in the best interest of the child.
How do you figure that out?
You have to look at the child, what they want. And then you have to look at, can the parents improve the situation with some help from DCF or whoever?
Well, let's say this. If we talk to 10 well-qualified social workers, I'll suggest you get 10 different answers. And they're all good answers, but I'd suggest they're all different. So how do we know whether parental rights should be terminated?
Don't know.
Well, we don't know, maybe.
No.
So now, as attorneys, we want to advise, whatever side we're on, we want to advise the strength of the case. Either you represent the government, and you've got people saying, let's terminate rights, or you're representing a parent who's saying, you see, they're going to terminate my rights. How do you evaluate the strength of the case?
I know they have to look at what's going on right now.
Do you?
Yeah,
Do you even know that?
because that's what the court looks at. It's what the current situation is. Yeah.
I would say that, I agree, that's one thing you have to do. But how do you, what resource you got this person, or this social worker, actually, social worker. You got the lay person and the social worker, you got your parents. How do you begin to advise what the strength of the case is? What do you want to look at?
Precedent.
You mean case law by that? That's the right answer. Okay, that's one of the first things you do. You want to see, what does the SJC say about it? Because, you know, remember this too for the rest of your career. If you're dealing in areas with painful, unpleasant, difficult, or complicated facts, it's not your job to sort that out. You're an attorney. Your job is to apply legal analysis to the facts. I never know what's best for these children. I don't even represent you. I represent an agency. I have no idea what's best for children. I'm not a social worker. I've never taken any social work classes. All I know about is the law, I think. And that's what you'll be doing. You know, it's human nature to think, well, lots of abuse, less abuse. The question is, what does the SJC do? And you will find certain fact patterns where a trial court judge has terminated parental rights, the SJC held no. That's not enough.
Cases that they have to read was the Linus decision.
Dr. Alliance?
The Linus.
I was the trial lawyer on that
Yeah.
case. That was my case. Well, there's an example. I can't tell you about the trial. But
That was a hypothetical.
I had hair when it started. A long trial. Leave it at that. But, you know, that's the way it is. But my point is, that's the way that we bring, as attorneys, certainty to term. Is that we never really resolve the facts. Fortunately, that's not our job. We don't judge people as to whether they, I suggest you shouldn't judge people as to whether they're good or bad people. You judge the acts as a matter of law, whether they're going to allow the government to meet its burden. That's what keeps you focused on the job, because you're useless otherwise. You're just another person with an opinion, like me or you or anyone else saying, oh, that's really bad. Oh, that's not so bad. That's kind of bad. No, that's really bad. That's useless as an attorney. So you begin to see the patterns, and you can grid this, actually. I suggest that you do when you start practicing. So you have certain fact patterns, and you see the way the SJC goes. And then, as attorneys, you take the facts in front of you. It isn't just an exercise game that we give you in law school. You really do draw analogies, except now the stakes are high. It's not just for some paper you're doing in law school. Hopefully you've been developing the skills here, where you now say, now I can draw analogies. This case of mine is just like this one. Now I can advise my client. You're not doing it by saying, here's what I think. You're saying, well, look, this is what the SJC has held. The SJC has held that when terminating parental rights, past behavior is wrong. So the fact that you've been sober for a week, against the fact that you've been using heroin for 15 years, it doesn't really matter too much. Today, you're okay. Conversely, smoked crack 3 times back in 1999 and haven't since then. Case law teaches me that on that issue, we're pretty strong. Have you covered adoption of Catherine yet? Okay. What was that? What was the holding? I know you
They
have.
probably don't remember.
That's a terrible question. I hate it. You can ask me that, and I won't even know most of it. It's the only case I know. But adoption of Catherine, as an example, says in Massachusetts there has to be a nexus between drug use or substance abuse and parenting. In some states like California, if you give birth to an addicted baby, it's per se unfit. The only thing that the government has to do is go to court with evidence that the baby was born positive, essentially. Here in Massachusetts, the burden of proof is very different. The government has to prove that the drug use impacts parenting skills. So then you can now advise your client, again, we don't judge these people. You should never judge your client in terms of who they are as a person. But you can say, well, okay, you like to use heroin? Fine, here's my legal advice. First of all, you're breaking the law, don't use heroin. But if you do, send the kids away for a week. Send them with grandma and grandpa, shoot up, sober up, get them back. And even if the government catches you using heroin, setting aside the criminal piece, it only goes to parental fitness if there's a nexus between drug use and parenting skills. It's an interest. Sometimes I leave out of that case when I talk about this because everybody has strong opinions about drug use, as we should. But if you just look at people and say, oh, heroin, you're bad, you're a bad person, bad parent, you're going to lose your kids. Well, as attorneys, though, we look at case law each and every time, and sometimes we're surprised by the result. Wow, that really naive social worker who thinks because you use heroin, you should lose your kids forever? Guess what? The government hasn't proven any nexus. So suddenly our case looks great. Okay, any questions? This is about all I want to cover. Okay, good.
Chris, I remember Maria telling me at one day, you probably don't know statistics, but I remember her saying at some point that that in fact DCF really helps many more families than terminates parental rights in reunifying through voluntaries, et cetera. I don't know if you acknowledge statistically or generally.
Well, let me respond with a question that I've used throughout my career, and I never want to deviate from it. It is as well. I agree with Maria Fornier. No, I'm just kidding. I mean, she's right, actually. Most cases don't even get into litigation. I mean, most.
Right.
Again, I'm not speaking for the department. This is publicly available information. It's totally confidential. But the vast majority of cases are just savvy as the sound. We're just helping families. People need some help. They get help from DCF. It's in rare cases that they become court involved, and even when cases are court involved, it's in rare cases that there's a termination of parental right. I mean, from my narrow perspective as a trial lawyer, that's all I see, obviously. But agency-wide, the great thing about DCF is most of the families are getting a reasonably positive experience.
Because obviously this class has only heard about the bad stuff. So.
Remember that as lawyers, we don't deal in good news for the most part. Right? We are involved in whatever end of this profession you choose. We're here because everybody else has failed, usually. If you're litigators, that is. Very different in other areas. But if you choose to litigate, you're no different than a soldier. You're there because the diplomats have failed. Yes?
This is more of a personal question, but have you ever experienced a time where you didn't agree with what you had to advocate for DCF because you thought maybe a parent deserved to keep their kids or something, but because DCF chose that they need to terminate? Or do you think usually you're on the same page as them?
I'll tell you. Well, no, it's a fair question that you should also always think about. I mean, the way I deal with that is, I look at the facts that I'm given and I think, can I meet my burden or not? Because if I really contemplate it, do I agree with what's going on? Well, I'll tell you, I don't know if I could even handle it because you just never really know. I get such a small snapshot of what's going on. I will tell you this, every time I have a TPR case, and I wish I didn't, because I always think, I don't know why we can't work this out. I mean, I go to court with the expectation that I can work it out. I really like trial work. It's one of the few things I'm good at. I would always prefer to try a case. My mission is to see if we can fix this. Because I think families have been around longer than governments, I think termination of parental rights is horrific. So I guess I've never really looked at a case and thought, well, if I were a social worker, I could fix this, but I've looked at a lot of cases where I think, I can't believe that we couldn't have worked this out. And sometimes it's because the parents haven't done something, sometimes it's because we've made the parents do something I can't figure out. But I'll tell you, my best advice to you about litigation, and it was given to me, is you have got to take yourself out of that picture. Because if you start thinking about what you want to have happen, you're not going to be any good as an advocate. You have to be dispassionate. And it's easy to say this, and it might not mean much in law school, but you've really got to be able to say, academically anyway, I don't care what these people do. What I care about is making sure as an officer of the court I meet my duty, to zealous representation, I apply the law to the best of my ability, I get the best evidence in, but what do I think about it? I don't do it. It's no different, I mean, not to bring everything down to sports, but if you do anything athletic, you don't, if you've got to run 10 miles, you don't think I have to run 10 miles when I want to run 10 miles. You just do it, right? So that's my answer to your question. I don't mean to sound evasive, but
No,
I mean, I will tell you this though, if a better answer is there have been times when I've been asked to advocate a position, and I will say, I can't do that, and here's why. You know, you're taking a position that's not supported by the law. But I have never gone into court with a position that I thought was unsupported by law. I've gone into weak cases all the time, and you will too. You know what Rule 11 is, right?
Yes.
Okay. I mean, that's your guide. Here's another question, the few minutes we have left. You know, if you choose a particular area of the law, as you ultimately will, and you're in front of the same judges all the time, what about the interesting question of, I've got a really weak case on at 3, and I've got a strong case on at 11, and I've got an annoying case on at 9, and it's all in front of the same judge. Think about that strategy. How do you handle that? I'll leave you with that thought, because there's no answer to that. Think about that for a while.
Thank you.
Thank you.